Dear viewers, I welcome you all for an important discussion today. We have a lot of articles, videos, and lectures on the ways in which MSME Act favors the suppliers on event of non-payment or delayed payment from the buyers. As we all know, that any act or law is enforced with a neutral view that it does not harm or benefit any one kind of party to any dispute unilaterally and unconditionally. That is what the laws are trusted for. That is, protection of anyone being suppressed by some other. Now, let's come to the point. As I have named the title for this lecture, The Buyer's Perspective. For any work to be executed for a purpose, there needs to be more than one party. The one who wants the work to be done, and the other who wants the work to be executed through him, or who wants to do the work for that person. The work may be of any kind. It can be of supply of anything. It can be supporting work for a supply. It can be services required for any purpose. Or it can be a mixture of supply, support, jobs, and services. In all, the first party who wants to get the work done will call it a buyer, and the other party who does the work for the buyer will call it a supplier. So we have a buyer and we have a supplier. The buyer is bound to pay for whatever work he wants to be done by the supplier, unless the work is done by the supplier for a charity or some other kind of obligation. So he has to pay. Now, the work to be completed, there has to be an agreement between the two parties, which has to be mutually agreed upon by both the parties. This agreement does not need to be a signed document only. It can be a verbal agreement also. But certainly, it must contain terms and also the conditions which regulate the whole process of work, right from beginning to the successful completion of the work and settlement of monetary conditions subsequently. After all, no one does an agreement for a work which he doesn't want to be finished without any dispute or without any quarrel or fight with the other party. Things do not go the way one expects. There can be disputes, small or big. After all, for continuing our lecture or our discussion, there needs to be a dispute. If there is no dispute, we don't have to discuss this point, the buyer's perspective. But where there is a dispute, a third party makes an entry. There has to be a solution for every dispute. It also has to be with a neutral vision so that neither of the parties is favored while the other feels humiliated. The third party can be a conciliator, an arbitrator, or a judge from some court of law, whoever he may be. There will be a third party who will adjudicate the matter and give a solution for the disputes. The third party has to be governed by certain set of rules or laws which are required for resolution of any or all kinds of disputes amongst the parties, that is the buyer and the supplier. So, as you all know, there was an act, namely MSME Act, which was passed by the government in 2006, with supplies or services or both given against certain agreement mutually agreed upon. This law was passed with a view to make a safeguard of the supplier rights against oppression by the buyers who do not pay against the supplies or services. Now, there has to be certain criteria which either buyer or supplier has to follow to get through this act. Unfortunately, the MSME Act 2006 sets rules for the supplier which are against the buyers in a situation where he defaults in making timely payments. Rules or laws are made not only to punish the defaulter, but it also ensures that the defaulter must be scared of breaching the contract, of the consequences, so that he refrains from being called a defaulter or abides by the terms of the law. So now, talking of the MSME Act 2006, this act has an overriding effect above all the prevailing and previous laws about which the act is made for and which are covered under the scope of this particular act. If you go through this particular act, there are 28 or 29 sections, So the overriding effect is from section 15 to section 26. Right. It means that if an agreement is executed with certain terms of payment, those become meaningless when a party files a reference under this act in a competent forum. So the forum here, it is called MSEFC, or Micro and Small Enterprises Facilitation Council. The case filed in MSEFC, we will call it council for our convenience. So the case filed in the council is called a reference by the aggrieved party seeking redressal from the buyer. Whenever a reference is filed in a council, a notice is sent to the buyer and a conciliation process is initiated. Both the parties submit their grievances and submissions, which the council evaluates and proposes an amicable solution, which is not binding to any of the parties. Means they may or may not agree with the solution given by the council. And in case either of the parties do not agree with the conciliation process or the solution given by the council, the conciliation process fails and the proceedings are terminated by the council. Now MSEFC has to move a step further, in which the arbitration proceedings have to be initiated. The council may by itself or through some arbitrator. The arbitrator may be some person or a group of person, a judge, a sole arbitrator, or a group of arbitrators. So through some other arbitrator or by itself, the council can start the arbitration proceedings, which has to be agreed by both the parties. But this arbitration proceedings, these have a binding effect on both the parties. The appointment of arbitrator has to be in accordance with the Arbitration and Conciliation Act 1996. I am sure that everybody will be aware of this act, Arbitration and Conciliation Act 1996. It has been amended from time to time, but whatever, we will call it Arbitration and Conciliation Act 1996. So, the appointment of arbitrator should be done in accordance with this act, where both the parties should have faith on the person or agency chosen by the arbitrator, chosen as an arbitrator. Right. If any party is not happy or satisfied with the arbitrator, the council has to appoint a new arbitrator. But the party who doesn't have the faith on arbitrator, he must give certain reasons. He must have a valid reason for not getting this particular arbitrator appointed in for deciding his case. All right. So now, when the new arbitrator is appointed, this arbitrator informs both the parties about his appointment and confirms the rules according to which the arbitral proceedings would take place. Till this point, I think everybody already knows. Normally, a reference against any delayed or non-payment is filed under Section 17 of the MSME Act. Now, what does Section 17 of the MSME Act say? It says that, I will read it now. For any goods supplied or services rendered by the supplier, the buyer shall be liable to pay the amount with interest thereon as provided under Section 16. So, there is a pretext to this Section 17. Let's see what Section 16 says. Section 16 deals with the date from which and rate at which interest is payable to the supplier. If the payment is delayed by the buyer, the supplier is entitled to receive an interest at 3 times the bank rate notified by the Reserve Bank of India. And the time for which the interest is to be paid again has a pretext under Section 15. Section 15 is a bit too harsh upon the buyers. Remember, in this lecture, I am with the buyers, as our title is the buyer's perspective. So, under Section 15, the time defined for making a final payment from the date of supply or completion of work is 45 days. There might be an agreement having certain payment conditions, But once a reference is made in the council, the time limit from which the supplier is entitled for receiving his due amount with a compound interest is 45 days from the date of supply or completion of the work. Remember, the MSME Act has an overriding effect on all the agreements or previous laws, whichever are covered in this Act. From section 15 to section 23 only. Earlier, I had told that it is from section 15 to 26, but the overriding effect is from section 15 to section 23 of the MSME Act. All the other conditions given in the Arbitration and Conciliation Act or agreement or whatever the kind of agreement both the parties are having mutually, other uh, other sections would prevail, but whatever is covered from section 15 to section 23 in the MSME Act, that will have an overriding effect on all the other laws. Okay. All these sections we are discussing now, that is 15, 16, and 17, are covered in chapter 5 of the MSME Act, which has a title Delayed Payment to Micro and Small Enterprises. He uh, so from this title of chapter 5, Delayed Payment to Micro and Small Enterprises, it is very much clear that reference in the council can be filed by micro and small enterprises only. If the supplier is a medium enterprise or it is a big industry, large industry, he cannot take the services of MSEFC or council for dispute redressal. So you must remember that the supplier making a reference in the council has to be a micro or a small enterprise as defined in the MSME Act. The criteria for micro, small, and medium enterprise, it is given in the MSME Act. So you have to go through that. I will not discuss it here. We will consider that our supplier is the supplier belongs to the micro or a small enterprise community. Right. Now we'll take an example. I will not take the names of the parties, means I will not read the title of the arbitration award, but we will discuss a case, a particular case. There was a buyer who floated tenders for supply of 256 generators along with associated works. The work included supply, installation, testing, and commissioning of the generators. It also had certain associated works like cable laying, civil works, earthings, which were required for beneficial use of the supplied generators. Generators cannot be put on ground and they can't be run. So there has to be a foundation, earthing has to be connected to the generators, certain more works have to be done, cable laying has to be done, cables have to be supplied. So these all works were required in this particular agreement. The tenders were called in 2009 and the rate contract had a time limit of completion of all the works within 1 year from supply or from one year from award of the work to the supplier. Here we are calling him a supplier. The contractor is not a supplier because this was a work contract, and work contract contains composite works, means it contains supply of goods, it contains associated works related to supply, and it contains services also. So but for convenience, as per the MSME Act, because MSME has pronounced this contractor as a supplier, we will call him a supplier for our convenience and for you also. So, the tenders were called in 2009 and the rate contract had a time limit of completion of all the works, that was 1 year from the date of supply or from the date of award of the work. The payment conditions read that 95% of the payments would be given to the supplier immediately after the supply, and remaining 5% would be paid after installation, testing, and commissioning of the generators, or all the other associated works were executed satisfactorily. Acha, in the in on an event that the supply was made, but installation, testing, and commissioning or the other associated works could not be executed by the supplier due to any reason or due to some lapse on part of the buyer, the 5% would be paid after 6 months of supply. So, in this particular agreement, 50% of the generators were commissioned as per the requirement of the buyer, but remaining generators were not supplied. No, those were just supplied and not installed due to non clearance of the sites. So, those were not installed. They remained uninstalled. Just those were supplied. Also, the buyer had some disputes with the contractor, with the supplier, when the work was executed for those 50% generators. So, the buyer withheld or recovered certain amounts on account of certain shortcomings for those generators. Had the work been completed as per the ideal conditions of the agreement, the supplier would have received a little over 6 crores and 50 lakh rupees. But now, with the dispute, he received 54 lakh rupees less than what he was expecting or what the agreement was made for. The last of the supplies were done in the month of November 2010. And as per the agreement, the buyer was to be paid the full amount not beyond May 2011. But this buyer did not pay the remaining amount of 54 lakh rupees to the supplier. In April 2019, the supplier moved to the State Council, in which State Council means in the state wherever the that particular supplier was situated. So, in every state there is a council, and for every council there is a name of the state which comes before name of that council. So, for Madhya Pradesh or for Delhi, Delhi MSEFC, Madhya Pradesh MSEFC will be termed. All right. So, this supplier, he filed a reference in the state council in which it was situated with a claim of balance amount of 54 lakh rupees. Also, he produced a claim of compound interest of 2 crore 88 lakh rupees till the date of reference. From what time? Since May 2011. His claim was that he should have been paid interest for 54 lakh rupees right from May 2011 until he made the reference. So this amount was rupees 2 crores and 88 lakhs. It was a huge amount suddenly. Means for 54 lakhs, he claimed an interest of 2 crore 88 lakh rupees. So his total claim was something around 3 lakhs 42,000 or so. 3 crores 42 lakhs. In the arbitrator's award passed on 5th October 2019. So this arbitrator, he took 6 months to pass the award. So in this award, it is mentioned that the supplier had claimed this interest at the rate of 36% of the principal amount, uh, which was balance, which was 54 lakh rupees. Also, he was so generous, means this arbitrator, he was so generous that it is written in his award that the interest could be claimed to the tune of 4.443 crore rupees. Means the supplier, he had claimed 2 crore 88 lakh rupees, but the arbitrator was willing to give him 4 crore 43 lakh rupees as simple interest. But the supplier had claimed only 2.88 crore rupees, so he had restricted the claim to this much amount only. Yes, he while passing the award, he along with 54 lakh rupees of his balance, remaining amount, he gave an award for 2.88 crore rupees as compound interest on that amount. Okay, it was as per the claim of the supplier. Now, if we go for a reverse calculation, this arbitrator, he has intended that the rate of interest should have been something over 42% instead of 36% as claimed by the supplier. But as he was on the side of law, he says that he was on the side of law. He didn't increase the claim as per his calculations while passing the word. There were some other issues also which seemed to be very much valid and were raised by the buyer during the conciliation as well as arbitral proceedings. But those were ignored or with seemingly intent overlooked by the counsel as well as arbitrator. Now, it is not an allegation, but certainly something was wrong there. Nobody would claim this much amount without any proper rules. So, there was also a clause in the agreement which was prohibiting the claim of interest by the supplier against any debt or dues or delayed payments. Those points we will discuss in the second part of this lecture. All right. Now, only interest part we will cover in this lecture. As it should be the case, the buyer was not happy with the award and he chose to prefer to challenge the award in district court. If you remember, I had mentioned that the conciliation was not binding, but the arbitration award was binding on both parties. But now here we have the buyer who is unhappy with the award and wishes to challenge it in a higher forum. So what does it mean? The buyer had no option but to accept the award and pay the principal amount and the compound interest till the date when the reference was filed and additional interest on cumulative amount from the date of filing reference until the amount was finally paid to the supplier. Or he would challenge the award in front of the arbitrator. If the award is to be challenged, one has to challenge it in a court only after depositing 75% of the amount awarded by the arbitrator under MSME Act under section 19. So, which section he has to choose? He has to go for a appeal under section 19 of MSME Act. All right. And he cannot make a request to the council for review of this award. It is prohibited by MSME Act. Here it is very much against the buyer that on one hand he is not willing to pay even the principal amount. On the other hand, he has to pay the amount along with interest awarded arbitrarily. So, as I told earlier, the supplier claimed an interest of 36%, whereas the arbitrator was not happy with even 42%. Means he was willing to award more than 42% while passing the award generously. The buyer is at the receiving end where he has to pay 75% to the court if he wishes to challenge the award, or he has to pay the 100% amount along with the interest. And later on, in the same award, the arbitrator mentions that I further pass the award holding the claimant also entitled to recover interest as envisaged under Section 16 of the MSME Act on the above total amount of rupees 3.42 crore from the date of filing of petition, that is 5/4/2019, till the realization of the whole of this amount. So, the arbitrator in this statement means to state that the total amount comprising of principal and compound interest from May 2011 till 2019, means in April 2019, on the date which the reference was filed by the supplier, it becomes the principal amount on that date. All right, and the supplier is entitled to a compound interest on this new principal amount, means 3 crore 42 lakhs. On what rate? 3 times the bank rates notified by the Reserve Bank until the amount is actually paid to him by the buyer. All right. So, there are certain laws which this particular arbitrator has violated. We'll discuss those laws now. We'll discuss the laws which govern the rate of interest and method of calculation the interest and see if those are different than what the arbitrators generally consider while deciding a matter. All right. Also, we will see the other aspects with the other aspects which affect generally the adopted practices by the arbitrators. Acha. We'll now first see what is given in the MSME Act. If you once again go through section 16, what it said? Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any other law for the time being in force, be liable to pay compound interest with monthly rests to the supplier on that amount from the appointed day, or as the case may be from date immediately following the date agreed upon, at 3 times the bank rate notified by the Reserve Bank. Now, here what does the bank rate mean? The Reserve Bank of India keeps an eye on the inflation rates, fluctuations in the national and international markets, and keeps a balance so that the value of rupee is not affected by it. For this purpose, it revises the bank rates from time to time. You must have heard about repo rates. Those are increased or decreased by the Reserve Bank of India. So, notifications are issued for revision of these bank rates from time to time. For the purpose of imposing compound interest on the principal amount, the arbitrator should have searched for the prevailing bank rates as notified by RBI at the time of award. Here, in this particular case, whatever case of 256 generators we are discussing, instead of awarding the compound interest at the rate of 16.2%, which is three times the prevailing rates of 5.4%, means at the time when this award was passed, the bank rates were 5.4% as notified by RBI. So, the arbitrator should have awarded the compound interest at the rate of 16.2%, means 5.4 into 3 is 16.2%. Okay. He was willing to award the compound interest at more than 42%. Whereas this supplier, he claimed the compound interest at the rate of 36%. If the amount is calculated with 16.2% rate of interest, the amount which should have been awarded comes to 1.33 crore rupees instead of 3.52 crore rupees. Means it is just almost 3 times the amount which should have been awarded to the supplier. Now, instead of 1.33 crores, he has awarded, this arbitrator has generously, open-heartedly awarded an amount of 3.54 crore rupees. Okay. If the buyer were to challenge the award, he would have required to deposit rupees 1 crore instead of rupees 2.6 crores, as he will have to deposit in the court in the present situation. Why 2.6 crores or 1 crore? See, it is given in the MSME Act that if against any reference or award passed by the arbitrator, if the buyer wishes to go to for challenging the award, he has to deposit 75% of the award amount in the court of law. Then only his case will be listened, heard by the court. Okay. So, in this particular case, he had to deposit 2.6 crores if he wanted to challenge the award. Okay. So, one thing we can notice here that it was unlawful on part of the arbitrator, while he considered 42% was even not sufficient, whereas he had awarded the interest at the rate of 36%. Actual award would have been at the compound interest rate of 16.2%. So, He could have calculated even more. Means if it was on his wish or his will, he could have awarded at the rate of 50%, 100%, or even more. So he was not going by the laws governed by the MSME Act. Acha, there is one more thing. Means it is an irony that the court has discretionary powers to release the amount in favor of the supplier if this particular buyer deposited 2.6 crores in the court under protest in order to challenge this award. The court has its own discretionary powers so that this court can release the amount, 75% of the award amount, to the supplier against a promissory note. It means just he will give an undertaking that if this amount becomes not actually payable to the supplier, the supplier would return this amount without any interest. All right. So the supplier, even if it is on the wrong face of the tossed coin, it gets ample amount to fight the case against the buyer right from the magistrate court till the Supreme Court. If even the supplier loses the case in any court, he has to simply return the amount as he received from the buyer. Means he will not pay any interest on this amount. Whereas he has sufficient time and sufficient forums to challenge wherever the judgment of whichever court where he fails to get the justice done in his favor. All right. From magistrate court, he will go to the high court. In the high court, from a single judge bench, he will go for a DB. And from if he loses in the high court, he has an opportunity to go to the Supreme Court. So, if even in the Supreme Court, if he loses the case, he will return the amount without any interest. Now, there is one more act. It is called as the Interest Act 1978. It is a very short but a very strong act. In this act, there are very few sections, and in the section 2A of the Interest Act, the definition of the court is given as a tribunal and an arbitrator. So, the tribunal or the arbitrator could be termed as a court under the definition given in this act. Section 2B, current rate of interest, means the highest of the maximum rates at which interest must be paid on different classes of. Sorry, there was a call on my phone, so my video just got interrupted. So we were discussing section 2B of the Interest Act. Section 2B, what it reads, which is the highest rate of interest generally given by National Bank against any deposit to the customer. Okay. Section 2C. Section 2C deals with the term debt. Debt or debt, DEBT. Debt, it is pronounced, and generally people call it debt. Debt means by liability for an ascertained sum of money and includes a debt payable in kind, but does not include a judgment debt. Here, this act covers the arbitrator and his awards under Section 2A. The act describes the rate of interest under Section 2B, which is the highest rate of interest generally given by national banks against any depositor. It may be FD or any other kind of deposit made by the customer. So, the highest rate of interest generally given by the nationalized banks, that can be given under Section 2B of the Interest Act. Okay. Section 2C clearly defines debt and clarifies that a debt arising from any judgment isn't included in the definition of debt. Section 2E tells that all other words and expressions used herein but not defined in the Reserve Bank of India Act 1934 shall have the meaning respectively assigned to them in that act. Okay. Now going through the words of the award, uh, the arbitrator enables entitlement of interest on the amount of rupees 3.42 crores from the date of reference, that is from April 2019, at the rate of 3 times the bank rates. It contradicts the clause 2C of the Interest Act. How? As the amount becomes a judgment debt as per the award, and as per this clause, the judgment debt does not qualify in the category of debt at all. Section 3A2 reads, nothing in this section shall apply in relation to any debt or damages upon which payment of interest is barred by virtue of an express agreement. Section 3C states that nothing in this section shall empower the court to award interest upon interest. The contentions of the buyer submitted before the arbitrator during the proceedings show that there was a clause in the agreement which was mutually signed and agreed amongst the buyer and the supplier, which prohibited the supplier from any claims of interest on any debt or dues. Here, the arbitrator ignores the submission of the buyer and instead of rejecting the claim of the supplier, enables him to receive interest on an amount which is a judgment debt under this act. So, there are many rules which have been ignored or violated while passing this particular award. Who has ignored or violated these laws? Certainly, the arbitrator. Thus, the award on being challenged with the application of rules discussed over here in this discussion and certain other relevant rules. These relevant rules and other rules we will be discussing in our next session. These rules which were ignored by the arbitrator, these may help us in fighting the case strongly against the suppliers. The foremost aim of any buyer must be an honest approach towards the timely payment. Yes, the buyer or any department or a company, whoever purchases or gets a work executed through some supplier, he must have an honest approach towards timely payment and truthful submissions, even if ever the buyer is bound to approach to a forum for redressal of certain grievance. With this, I finish this discussion from my side and expect others to participate in a healthy debate in the comment section. Remember, this discussion is meant with the buyer's perspective only. That is what our topic is. So, thank you so much. I will appear soon with the concluding part of this discussion, in which we will cover the other aspects and other rules whichever were ignored by the arbitrator and the council also while holding the proceedings under the Conciliation Act. Okay. I will be posting some citations also from High Courts and the Honorable Supreme Court in the comment section, which may be helpful in case you are dealing with similar cases. So, thank you so much. I will now expect that we will have a healthy discussion only with the buyer's perspective. Thank you.